Welcome back to It's Your Law. I'm George Curtis, and we got a new guest, Ray Edelstein. Welcome to the show.
Hi, George.
You've been in the criminal law practice for quite a few years, haven't you?
About 26.
You were a prosecutor at one time.
I was.
And how long have you been doing defense work?
I've been doing defense work for longer than I did prosecution work. It's going on about 16 years.
All right. And you and Mark spent a good chunk of the past year getting involved, first of all, scouting the Steve Avery trial, and because that went on before your Dassey trial, and then handling the Dassey trial yourselves.
Right.
I said my first question to you was going to involve the Constitution. It's been my observation that when I was a criminal defense lawyer, I was always reading the Constitution, and since I've been suing insurance companies for a living, I know where it is, but it's dusty.
Well, in criminal law, you have a lot of constitutional issues. The biggest one you run into most often is Fourth Amendment stuff, search and seizure. In this particular case, there were lots of search warrants, so we had, of course, to take a look at all the affidavits in support of the search warrants, ensure that they had a basis for the court to issue any warrants, and then the remedy, of course, is suppression, but the tables have turned over, even in my practice. It seems to me that there were more, the courts were more apt to recognize the rights under the Constitution than what we have today. They've expanded it where you have good faith exceptions. They've expanded it to a real gray area, totality of the circumstances, and having, instead of having more definitive, more easily definable standards. And I think that that's led to some abuses because the police have taken advantage of that, thinking that perhaps they can get this one past a trial judge.
Now, thinking of the cases, the criminal cases that have gotten the most attention across the country in the last year or two, I think most of them have been the Enron-type white-collar crime cases where we find that people were investors in major corporations, and they were misled as to the health of the corporation. In the meantime, the people at the top were cleaning up and self-dealing and things like that. But those kinds of cases don't involve the kind of emotional evidence that you get in a homicide case. I bet there were some extremely emotional bits of evidence in your Dassey case.
Well, there's no question. You know, you have a young woman who, by all accounts, was a fine young woman, came from a nice family. Contrast that with the individuals in this particular family, and by that I mean the Avery Dassey family, if you will. The family, by and large, operated a junkyard. It was a salvage yard. They lived in a rural area. They did not wear white shirts and ties. You know, this was a very working class family, and while they might not have been the Norman Rockwell family you might see on the magazine, the mere fact that they ate venison and drank beer at Thanksgiving didn't mean they weren't a family. And that type of family is entitled to their day in court, just like the Norman Rockwell family that the state attempted to depict the Hallback family as being.
But there must have been some vivid evidence, testimony or otherwise, about Teresa Hallback that really placed an emotional burden on you in your defense of Dassey.
Well, it's clearly emotional for a jury when they're having to deal with the disappearance, the graphic description of a rape, and ultimately the disposal of a body through incineration. They were presented with small items of personal property. These are the remnants. You didn't have the gory, bloody pictures, if you will, that sometimes are accompanied in a homicide case, which almost made it even worse, because now you've got 12 imaginations running wild. And that does make it very emotional, and it's not favorable toward a defendant, obviously.
How do you keep the jury focused on the presumption of innocence, the burden of proof, the unanimous jury verdict requirement the evidence in the Constitution when there has been a death that must have been gory?
Well, they take an oath, as they do in any case, and you try to remind them of that. You try to ensure that they focus on those bits of evidence, be they in existence or by negative implication. For example, in this case, there was part of Brendan's statement that her hair had been cut. Evidence was presented through cross-examination that the government never once examined the contents of the vacuum cleaner found in the Avery household. If they were looking to confirm and affirm the validity of portions of his statement, it seems to me they should have done that. That might have created reasonable doubt in the mind of some juror. It's a very simple thing to do, and they simply chose not to do it.
Most important right I think we have as citizens is the right not to incriminate ourselves, the right to keep our mouths shut. And those of us who have done criminal work and still do criminal work, I suspect the first question you ask is the first one I always ask, of did you talk? Because every time an accused opens his or her mouth, the chances of us having a successful defense go down rapidly. And you had a client that apparently couldn't stop talking.
Well, he did a lot of agreeing. I wouldn't say that he was the originating source, if you will, of what turned into be his statement. There were lengthy interviews with well-trained officers, and they admitted that they were the source, and they did suggest to him the answer to many questions they put to him. And while he might initially deny it, they would revisit it over and over and over, almost until they got the answer that they wanted, and doing things like praising him, for example, when he gave an answer that they liked, almost suggesting as if he could be rewarded if he gave them the answer that they liked. There was an expert that testified about his suggestibility and his intelligence level. And that was part of the theme that we had, that even though he made a statement, this jury had to decide if this was truly the product of his knowledge or whether it was something that was planted there and he adopted originating from the police officers, or he simply was spitting back information that perhaps he learned from Steve Avery.
Our second segment is out of time, Ray, and we're going to come back and then visit the trial results, what happened at sentencing, and what options, if any, that Brendan has from now until the rest of his life. He's a young man. He is going to be serving considerable time unless there's some kind of legal reversal on appeal that can be accomplished. And I know there were negotiations throughout the trial where you and Mark passed on to him that some offers were being made, but he made a decision, and I want you to discuss why you have to go along with what the client wants. We'll be right back.